husband, who was on the site that day as well, came over and just clocked my client in the face and started this, scuffle between the two of them. My client finally subdued, the husband, the male employee. And then, my client explained that the husband sort of turned his ire towards his wife, and he was very frustrated with her that she was even having a conversation with my client. And that's when my client said the husband had grabbed the female employee's arm. He kind of took it as, well, I probably deserved that after what happened in the past. And he was going to just drop it, right? And figured he wouldn't see them ever again. But 3 days later, he was arrested on these charges, assault fourth degree with an allegation that he tried to, kiss her on the site.
If he were deported, he'd essentially lose his family and his family would lose him.
Right, that was his concern. The underpinning of the whole defense was this affair, right? And when she testified and I cross-examined her, I asked her about the affair and she denied it outright. She said there was no affair. And that's all she said. She said there was no affair, and then she didn't say more about it. It's scary what an accusation can do, especially in a case like this where you talk to the officer on cross-examination and you realize how little it is that he actually did to investigate the case.
Your client was essentially charged with this crime based on statements from a lady and her husband. And that is enough. That is enough for the prosecution to indict somebody and take them to trial and send them to prison. The testimony of a single witness is enough. Today's case is one where the client was accused of a fourth-degree assault charge with a potential penalty of up to 12 months in jail, and more importantly, there was a chance he would be deported. Today's guest is attorney Michael Durborow. For all you Louisiana folks, just like Burrow, but Durborow.
That's right.
But before we get into the case itself, let's get to know a little bit about Mike. You go by Mike or Michael?
I go by Mike, yeah. And Chris, thanks for having me on. I'm really looking forward to the opportunity to talk to you.
Same here. So Mike, why don't you tell us a little bit about what inspired you to pursue a career in criminal defense?
So I went through undergrad at the University of Kentucky in Lexington, and I was getting close to the end of my time there, looking at graduation. I was studying business marketing, actually, and I did an internship with an organization, a company by the name of Alltech, and I did that throughout the summer before my graduation. And it was the first time that I had worked a true 9 to 5. And I really got the understanding of how long that is every day. So it made me recognize and understand that I really need to find something that I want to do if I'm going to have a, several decades long career in something. So after going through that experience, it actually coincided with a time frame where I was getting a little bit more involved with a campus ministry, Christian student fellowship there on the University of Kentucky campus. And I started to realize I wanted to do something meaningful with my life. And I had it down to 3 different career paths that I was considering. And I narrowed it down to law school. And I decided I wanted to go to law school. And I thought I wanted to do and practice family law, help people going through tough situations like divorces or custody battles, help out with adoptions. I actually had the opportunity to shadow in family court. And it just took one family court appearance for me to realize that's not what I wanted to do, with the judge telling both parents that they had to sit together at their daughter's track meet and they couldn't argue. And so I was really on a quest while I was in law school to figure out what I could do that would be the most helpful, helping people who are in the toughest situation. And it was actually my last semester of law school. I got an opportunity to do an externship with the Department of Public Advocacy, the Public Defender's Office in our state. And that was my first exposure to criminal defense. And I fell in love with it, Chris. I loved every aspect of it. I loved getting to know the people who were charged with recognizing them as human beings and then being able to go to bat for them in terms of, a lot of times it's the whole community, at least the whole courtroom, against maybe one person, and you're the only person standing there representing them. So that was a really eye-opening experience, and it evolved into 5 years with the public defender's office, and then now I'm in private practice.
Where did you grow up, and how did that shape your views on justice?
Yeah, so I grew up here in Lexington, Kentucky, where I currently practice. And, parents that I have, I like to say I chose my parents well, right? Because
That's
obviously
right.
none of us get to make that decision, but I feel just tremendously blessed with the parents that I have. They provided for me, they gave me opportunities, they taught me right from wrong. And throughout my life, I've come to recognize that not everyone had that benefit or that blessing. So, really, growing up with parents like that, it instilled an obligation, a sense of responsibility in me to try to figure out what I can do to give back, right? To maybe bring some order to the chaos of the world. Maybe I was blessed with parents like that so that I can help people who didn't get that same blessing in their childhood.
That's great. I was actually listening to a podcast recently. It was a debate between a Christian, an atheist, and a science, like somebody who was faith was based on science. And they were talking about, humans finding their purpose. And, things don't really satisfy us. It's not until we actually find our purpose in life that we can be happy. No amount of money. If you have money and no purpose, you're not happy. So purpose is great. And it's great that you have somebody who, allowed you to find your purpose and help set you on the path to finding that purpose.
Yeah, absolutely. Absolutely.
So let's talk a little bit about criminal defense. What's a typical day like for you?
Yeah, so fortunately, we stay pretty busy here. I work at a firm, Surrey Law, Surrey and Associates. So we get a lot of calls every day with potential new clients. So I'll spend a good portion of my day on the phone talking with potential new clients. We have cases throughout the state. So I spend another portion of my day traveling to and from courts, appearing in front of courts. And then when I'm back in the office, reviewing discovery, talking to existing clients, it really is the fast paced environment that I like about criminal defense, in and out of courtrooms, in and out of the office, visiting crime scenes. Yeah, so days are usually pretty jam packed, and that's a good thing.
When you travel to and from these courthouses, I know I travel a good bit as well. In fact, I do LWOP cases, life without parole cases in Lake Charles, Louisiana, which is 2 hours from where I live. But I do them for the public defender's office over there, and I still have a private practice. So how far do you typically travel when you are traveling?
Yeah, so the Fayette Courthouse is about a 5-10 minute walk down the street from my office. So that's about as close as it gets. And then I try to cap it at about 2 hours from
That's right.
Lexington, with a lot of cases falling about an hour away.
On those 2 hour drives, the reason I ask is because when I'm on those drives, I'm typically listening to something that's gonna educate me. Like I'll be on YouTube listening to National Association for Criminal Defense Lawyers. I'll listen to some of their stuff. I'll listen to real trials that have occurred that are on YouTube. I check those out. If it's 2 hours to get to a courthouse, it's also 2 hours back if there's no traffic. So how do you typically take advantage of that time?
Yeah, that's a good question. I recently started downloading Audible books, so listening to books on tape essentially on the Audible app. And that's a great way to kill some time. Here recently, been listening to a lot of books on marriage. My wife and I, we just recently celebrated 10 years of marriage, and it's something that I'm like, I need to just keep investing in this and
That's right.
continue to figure out, yeah, the things that you need to do in a long-term relationship. But books on that, sometimes religious books. I listened recently to The Great Divorce by C.S. Lewis. That was an interesting book on tape. But yeah, that certainly fills the time when you can have something to listen to.
What would you say is one thing that people typically misunderstand about what you do?
Yeah, I get that a question about, how could you do what you do quite a lot. Sometimes it's a positive question. People are genuinely curious. Other times, people are seemingly upset that I do what I do. So I try to reframe it when someone asks me with maybe a critical tone that, it's not that you're representing the crime, right? You're representing the individual. And really, the fact is that we all make mistakes. We all mess up. People who have been charged with a crime, they've been caught doing something that, typically they do regret, or something that they, made a mistake doing, or they have a substance abuse problem, or they have an addiction, or they, had a lot of trauma growing up and they haven't been able to process all of that. So, I think it's a misunderstanding to just hear criminal defense and think, oh, you're a big proponent of crime. You like to keep criminals on the street, something like that. When in reality, it's just a person that you're representing that is going through a really dark time. And it's just really an honor and a privilege to be able to walk with them through that dark time and try to use what I know to help them.
I always tell people when they ask that question is one of three things. First of all, in general, it happens more often than people are willing to acknowledge. Like, innocent people get arrested and charged with crimes. Number two, I represent a lot of people who are going to go to prison probably and deserve some time in prison, but where's the equalizer? Like, my job may not be to keep that person out of prison, but make sure the time they have to serve is fair based on the crime they're accused of. Certainly, we don't want only the judge or only the prosecutor deciding how much time a person is going to get for a crime, because I think everybody would just be lumped together and thrown away. Our job is really to help balance justice. In addition to ensuring that it's properly administered, we want to balance it. So, what we do is important, despite what some of our clients may have done.
Right, exactly. So much of it is that mitigation, right? Leveling the playing field, like you said, because they're going up against someone who has been experienced in the law, a prosecutor who did go to law school, who a lot of times has been doing this for decades. So, yeah, certainly trying to give them a fair shake. But yeah, and you can't always avoid jail time, and sometimes they deserve jail time. And yeah, but what's the right sentence? Absolutely.
So I gotta ask, what sets you apart? And when I say you, this is twofold. Because I know there's a lot of criminal defense lawyers and firms in Lexington. So what sets you apart in criminal defense, and what sets your firm apart from other firms?
In terms of setting myself apart personally, a lot of people that I have talked to, in law school or in the practice of law, you'll hear things like, I'm in this to make as much money as I can, or I went to law school to become a lawyer so I can just make as much money as I possibly can. And, for me, we've touched on this a little bit before, but it really is a calling where I do feel passionate and I feel like I've got a purpose in representing people who are going through such a difficult time. So I think that passion comes through in my representation, really trying to get to know the person, trying to figure out what it is that they're looking for, what outcome they're looking for on a personal level, and trying to accomplish that for them. Now, in terms of our firm, a lot of firms are, solo practitioner firms, especially in our area. That's fine. But we have a very big team. We've got offices in Cincinnati, Lexington, Louisville, Indianapolis, Georgetown. We've got, I believe it's 8 attorneys, 7 or 8 attorneys in our firm. Every morning we have a morning meeting, 8 o'clock video conference call where, it can go anywhere from, 5 minutes to 30 minutes, where we have that brain trust where we can run issues by, 7 or 8 very experienced attorneys. Any issues that we have that we haven't come across before, we can run it by the brain trust. I think that's an incredible asset that we bring to every single case and every client.
So the case that we're going to talk about today, can you give us an overview of the case, the allegations your client was facing or accused of, and the penalty he was looking at?
Yeah. So my client, he was facing up to a year, 12 months in jail on an assault fourth charge, a Class A misdemeanor here in Kentucky. And you touched on this earlier, but one of the biggest issues and concerns about my client specifically was that, he had the potential of deportation based on his immigration status if he did obtain a conviction in this case. He is a DACA, a dreamer, so it's something where he had to renew every 2 years, and he was very concerned if there was any conviction on his record could result in deportation.
You just used the term, I had to write it down. You said a docker or a dreamer. What is that?
Right. So DACA, Deferred Action for Childhood Arrivals. This is something that was put into place, I believe, in the Obama administration. Essentially, it protects young, undocumented immigrants who were brought to the U.S. as a child from immediate deportation, and it also allows them to get a work permit. And the renewal is every 2 years. So this was something that applied to my client, and his renewal period was coming up. So he was obviously very aware of any criminal conviction and the impact that that could have on his life. I mean, he has a wife and children here, in the U.S.
Does your firm do immigration law or it does not?
We don't do immigration specifically. We actually have a partner here in the Lexington office, a firm that we refer cases to in the same building as us. So no affiliation with our firm. But yeah, when we get those specific issues, we do have someone in our building here who we refer to and can work closely with for any of those issues.
So what I'm hearing is if there's an immigrant or legal or illegal and they have a criminal case, you guys at least understand that there could be an immigration related issue, and you'll handle the criminal case and send them to somebody who's reliable to handle the immigration matter. And you guys can your firm and that lawyer or that firm can kind of work together to make sure or to try to get the best possible resolution in the criminal matter and the immigration matter. Is that fair to say?
Absolutely. We do that fairly regularly, especially in today's climate. We, partner with this firm in our building quite a lot.
So let's talk about how the client actually found you guys. How did he find you and your firm?
The initial meeting actually was between me, the client's mother, his sister, and his wife. The client was incarcerated, so they found us online and then came into our office for an in-person meeting. Joe Surrey, the owner of our firm, he does an excellent job with marketing to really expand our reach throughout the state.
So I want to know about the wife and the mom, their emotional state when they came to see you, and when you guys made it out to see the client, what was his emotional state like?
They almost seemed to be in a panic, very concerned. This isn't something that they had ever dealt with before. And, the craziest part about it was that my client was given a $100,000 bond by the judge. So, we were immediately trying to figure out, strategy to get that bond down. And he had an upcoming arraignment where we were able to address that with the court pretty close in time after that initial meeting with his family.
Were you able to get the bond reduced?
Yeah, we were able to get it down to 5,000 cash, and they were able to post that and get out. Yeah, I mean, it was a tremendous bond, not something that I typically see on a Class A misdemeanor in Kentucky. So it was a bit shocking to me, and the judge brought it down pretty quickly when we addressed it with him.
I got to hear that because that's like a 95% reduction in the bond. That doesn't happen here in Louisiana. What did you guys do to get the bond lowered that much?
Yeah, so what we do in Kentucky, we've got pretrial services that go in and interview an individual charged with the crime, and then they will assess a level. And there's two different levels: a new criminal activity level and a failure to appear level. Obviously, the higher the number on a new criminal activity, the more likely it is that they're going to commit a new crime if they're let out. And the higher the number on the failure to appear, the more likely it is they won't appear if they're let out. So the lower the number, the better. So we obtain that number just as soon as we can. That report, it goes through all criminal history, age, employment status, a lot of helpful things that you can bring up with the judge. And of course, when you do have an ability like this client's family did to post a cash bond, that certainly helps when the judge sees that the client has some skin in the game.
So when you dove into the case, I'm assuming at some point the state had to turn over discovery, which was the evidence they had against your client. What were some of your initial doubts and fears with respect to that?
There wasn't a ton of discovery in this case, at least initially. We were really looking at a citation. It's like an arrest warrant affidavit from the investigating officer laying out the allegations in the case. And then so we filed a motion for discovery to get everything that the county had. The judge actually gave us a deadline to respond to that discovery. So we provided some of our own reciprocal discovery to the county, and the deadline came and passed, and we got nothing else from the county. But then it was several days after the deadline, they produced some photographs of the alleged victim's arm with some bruising on it. It was nothing that was produced earlier on in the case, but only, like I said, after that deadline. So that was something that we certainly had to take a look at. But, once I talked to my client about that piece of evidence, he was very quick to explain that in the altercation that occurred that day, the accuser, who was an employee of my client, actually, it was her husband who was the one that grabbed her on the arm and caused that bruise that day. And if it's helpful, I can go into kind of a broad overview of what happened that day.
Yeah, let's do that. I would like you to take us through the incident, like step by step, play by play, what happened that day or what allegedly happened that day.
Sure. So, my client is the owner of a construction company. They primarily specialize in roofing, residential roofing projects. Him and three of his family members own this business. He's one of the four owners. And on this particular day, they were doing a roofing project on a home in the community. My client, as one of the owners, went out to get some beverages, some drinks for the crew that was on the roof, some Ale-8s, a local soda here in Kentucky, and some waters. And he came back to the work site, and he was in the process of handing these drinks out. He offered a drink to the alleged victim, this female employee of his. She declined the drink, and that was a little bit peculiar to him, but he understood because he had actually had an affair with this female employee about a year prior to this. So, when that affair came to light, this female employee and her husband, who also worked for the company, they left the company and no longer were there. But then about 6 months after they left the company, they came back to work for the same company. And, the question that I had was, to my client, why would you let people with this history with your company and yourself come back to work for you again? And he explained that it was really over his objection. There's four owners. He doesn't oversee the hiring, he does the marketing. And so he objected to this, but one of his family members nonetheless brought them back on board. So on that day, after she rejected the drink, he went up to the roof to pass out these drinks to the crew members that were on the roof. He came back down from the roof, was putting the drinks into the coolers that were there, close to where he had parked. And this female employee came over to him to get a drink from the cooler, and he, addressed the issue. Why did you, reject the drink earlier? Didn't get a clear response from her. And, so they were talking, and during this conversation, her husband, who was on the site that day as well, came over and just clocked my client in the face and started this, scuffle between the two of them. My client finally subdued, the husband, the male employee. And then, my client explained that the husband sort of turned his ire towards his wife, and he was very frustrated with her that she was even having a conversation with my client. And that's when my client said the husband had grabbed the female employee's arm. And then after they had a bit of a discussion, they got into their car, the husband and wife employee, and left. And, my guy, while he was frustrated that he just got clocked in the face, he kind of took it as, well, I probably deserved that after what happened in the past. And he was going to just drop it, right? And figured he wouldn't see them ever again. But 3 days later, he was arrested on these charges, assault fourth degree with an allegation that he tried to, kiss her on the site. And so that's really the background of what happened in the case, according to, she accused him of grabbing her arm. That was the basis of the charge.
Strategy. You get the facts, you get the citation, you know what they're saying, you know what their evidence is, you know what your client's version of the story is. What was your strategy in taking apart the prosecution's case, and how did you go about developing that strategy?
Yeah, so one of the key pieces of evidence early on in the case was a image that my client had taken because when he first got to the site that day after picking up the drinks, he had done some aerial drone shots of the roof for marketing purposes, and it really painted a nice picture of the scene that day, or actually captured it exactly, and it showed 12 or 13 different individuals on the roof that day, showed that it was a bright sunny day, showed that there was a road going in front of the house, in this neighborhood. And the fact that there was just, two witnesses in this case, the accuser and her husband, really stood out to me as an issue that the county was going to have to overcome. If this did really happen the way that the alleged victim said it happened, why weren't there more witnesses who can attest to this and verify what she's claiming happened?
I'm assuming you get to play that drone video, or at least still images. You get to use those in court.
Yeah, so what we did, we had two still images, I believe, in the drone video that we produced to the county. And then I wound up just printing out multiple copies of that still image showing all those workers on the roof and the road in front of the house, and then passing that out to the jury, really to make our point.
Okay, so let's go to the trial. Your client is out of jail. He's happy to be out, but he's still concerned about his status as a dreamer, right? If he's convicted, he's probably more concerned about that than potential of 12 months in jail, I would imagine.
Right. So, obviously he very adamant that he wasn't going to plead to anything because A, he said he didn't do this. And B, he said as a business owner, his background gets ran a lot by all prospective customers. So he couldn't have, especially a false allegation, conviction on his record. And then absolutely the DACA status was kind of the underlying stressor in the case.
If he were deported, he'd essentially lose his family, and his family would lose him.
Right. That was his concern.
All right, so let's go to jury selection. How does jury selection work in Kentucky? And I know most lawyers, most of us that do trial work, we blend in our theory and theme in jury selection. So I want to know how you went about doing that.
The way jury selection works in Kentucky is, you'll have just a big panel of individuals, who show up for jury duty, and then the judge will call forward the individuals who are going to be considered on the panel. So for a district court trial, there's 6 individuals who sit on the jury. So this judge pulled up around 12 to fill up the jury box. And then so when you're addressing the members that are sitting in the jury box, you're also speaking, loudly enough so that everyone in the auditorium can hear, because if one gets struck, then they'll just send one from the panel up to the box of 12, right? And then at the end of that, voir dire session, you'll have the option to strike the jurors that you don't want. And then both sides are compared, and then you have the 6 that are remaining. So in terms of theme, for addressing the potential jurors, I mean, I can't say it enough, how much we hammer home the presumption of innocence, right, and the Commonwealth's burden of proof, right? Just to lay out, how high of a standard the Commonwealth has to meet in order to get this conviction. So I'm hammering that home very early on in the case, and that's just a consistent theme throughout, and then really bringing it home during the closing.
I'd imagine, especially in a case like this where the evidence against your clients is essentially the statements and credibility of the alleged victim and her husband. Let's go to opening. You blend that in jury selection, hammering home how important it is to hold the state to their burden, because I always say we need to hold the state to their burden, because when we don't, innocent people end up in prison. So after jury selection, we have opening statement. In some states, the defense goes first. Most states, the prosecution goes first. How is it done in Kentucky?
The prosecution gets the first bite at the apple for opening, and then they get to go last in closing. And that's something that, I touch on in closing, that, the prosecution gets to go first, and then they get to go last here today. This is the last time you're going to hear from me, and the prosecution, they get that advantage and that leg up in a sense because their burden is so high. right? And they have such a high level to overcome. So they get the last say today.
So, in opening statement, I want you to touch on the prosecution's opening statement, and then how do you respond in your own opening statement on behalf of your client?
So, really going in opening statements, my goal is to just tell the story, not necessarily to even respond to the prosecution, but just to lay out the story. And I don't even get into the evidence is going to show you this, and this is what you'll see, and this is what you'll hear. I just tell the story, starting with, my client, and this is how his day started. This is what he was doing. This is what happened. That was peculiar because of this. And then after that, this happened, just really walking them through. And then at the end, asking them to find, the verdict of not guilty at the end of the trial.
I like how you do that. I think sometimes I see lawyers, criminal defense lawyers, in opening statement oversell or overpresent their position. When you do that, you essentially put stuff out there that the prosecution can throw back in your face at the end of trial if you don't discredit what you claim you're going to discredit, or if you don't show what you claim you're going to show. I like the way you do that. I think it's important for us as criminal defense lawyers to understand you're not going to win your case in opening, so it's important not to oversell your position in opening. So after opening statement, we get to the witnesses. Who are the key, vital, important witnesses for the prosecution in this trial? Because I want to go through them each one by one.
Their first witness was the accuser, and she got up and testified. Now, she spoke Spanish primarily, so she had a translator there, which, I think for whatever it's worth, that certainly has to be harder to connect with the jury when you have someone translating for just a kind of a hard fact about that.
What does she say during her direct by the prosecution, and how do you deal with that on cross?
Basically walks through, the day, what happened, saying that, my client had grabbed her by the arm and tried to kiss her. And, that's when her husband came over and punched my client in the face. And then, they left and went and tried to report it to a police station. And I believe they maybe went to the wrong jurisdiction. So they were told to go somewhere else. I mean, she had kind of a long story of what they did after the fact. But yeah, she kind of went through step by step what she was saying occurred. Now, her testimony was different than what was in the citation. I mean, it was just a small detail, but she said that the altercation where my client grabbed her arm, her allegation, occurred by the house, under the awning of the house. And the police report, it said that it happened by the dumpster that was a little bit of a distance away from the house. So there was an inconsistency there that, I tried to pick up on, kind of getting into the cross. I don't know if you want to get into the cross now.
I think we can.
Getting into the cross of her. So I tried to nail that down, right? Her inconsistency. But first I needed her to recognize what was in the citation. So it was a bit of a tricky process because there was a translator there, right? And so, and I couldn't just say, read this citation and tell me what it says, right? That's got to go through the translator. So that was kind of a tricky aspect of it. But ultimately, she then agreed with me in cross that it happened by the trash can. So that was different than what she had testified to
a few minutes earlier.
Right. And then the prosecutor got back up and tried to clean it up and say, now, this actually, it didn't happen the way that the citation says it happened. It happened like what you just testified to by the house, right? And you just had a hard time communicating with the officer because he didn't speak your language, right? And so she agreed to that. And then I was able to, recross and say, but you confirmed earlier to me that it happened at the trash can. And you have a translator here today, right? So she didn't have that same excuse. So I think that scored some points with the jury. But kind of the underpinning of the whole defense was this affair, right? And when she testified and I cross-examined her, I asked her about the affair and she denied it outright. She said there was no affair. And that's all she said. She said there was no affair. And then she didn't say more about it. So then when the husband got on the stand and testified, I confronted him about the affair because he was outside of the courtroom.
That's where I was going to ask. After the accuser, was the husband the next witness?
The prosecution had it in a funny order. They actually called the investigating officer in between.
Let's talk about the husband, because just for those who don't know in the audience, we typically do is sequester the witnesses, which means the witnesses are not sitting in the courtroom listening to what the other witnesses say while testifying under oath. So we can kind of keep them from influencing each other's testimony. It helps the truth come out in the courtroom. I'd say we go to the husband next because the investigating officer wasn't there. He wasn't a participant. He's not that important. So tell me what the husband says on direct when the prosecution questions him, and how you deal with that on cross, as well as weaving in what you got out of the wife on cross to kind of support your defense in this case.
Sure. So he testified to the basic narrative, that was in the citation. It seemed like they had their story straight, right? I mean, husband and wife. And he just went through, said he saw my client grabbing his wife by the arm, and he went over, or whatever he saw their interaction, and he saw my client grabbing his wife by the arm. And that's when he went over and punched my client in the face. So he went through, a similar series of allegations that his wife went through. And then, I got the opportunity to cross him, right? And I think the biggest point that I wanted to touch on was the affair, right? And, because that was going to be our argument as the motive for him making up this, being a part of this false report, right, to law enforcement, because he was so frustrated with this employer who had previously had an affair with his wife. So I asked him about there was no affair. It was just your client consistently and constantly reaching out and communicating to my wife. Like it was a one-sided thing, right? And that's not what his wife said, right? She just said no affair. And she didn't elaborate, right? And then the husband said, well, it wasn't an affair. It was just your client wouldn't leave my wife alone. Okay, so that was a problem, right? I mean, it's a problem for their story, but it's also a problem for us because, we've just got my client who's testifying to an affair, but then you've got two people, although in different ways, denying the affair. One thing that I had anticipated, because I didn't have anything in writing from either of them, right, that there was an affair. So I knew that they could very well likely deny that there was ever an affair. So I had asked my client's wife, to sit outside the courtroom. So she was sequestered too, so that she could testify if needed, right, to confirm this affair. Because I talked to her about that, and she said, yes, there was an affair. But I also hadn't talked to her, specifically enough, right, to say, was it just one-sided, your husband, or was it two-sided, right? So it was a bit of a risk to call her because I didn't know exactly what she was going to say, but I felt like it was important enough because I was very confident that there was an affair based on communications with my client and with his wife. I just didn't know what she would say. So we had to call her separately, and we can get to that.
We've handled the accuser. She says no affair. Then we have the accuser's husband saying no affair, but your client was pursuing his wife. And then we have the investigating officer who we haven't touched on. Do we need to talk about him or not really?
Yeah, so it was just a pretty straightforward cross-examination. I mean, he essentially read through the allegations, from his citation. And so when I got to cross-examine him was, did you talk to any of the employees who were there that day on the scene when this was alleged to have occurred? No. Did you talk to my client? No. Did you try to talk to my client? No. So the entire case was brought based on statements from the husband and wife alone. Yes. Don't you think it'd be helpful if you had talked to maybe some employees who were there that day? Wouldn't it have been helpful to your investigation if you had at least attempted to talk to my client to get his side of the story? And he basically agreed, but confirmed that he had really done not a lot.
He could have inquired as to the allegations. Did your client ever actually grab the accuser by the arm? The job site had a bunch of workers. some of these people probably knew about the affair. He could have said, hey, can you tell us why this would have happened between these people? Was there any kind of bad blood? Was there some kind of history that may be important to this investigation? And certainly he probably would have learned about the affair that the accuser and her husband are now in court under oath denying ever happened.
Right.
Does the prosecution call any other witnesses, or do they rest after these three witnesses and now it's the defense turn?
They rested, yes.
Now, I know what's true in most criminal defense cases. Number one, our clients are not required to call any witnesses or testify. Number two, most times there are no witnesses that we have to call. But this case was an exception, right?
Right. So, that is certainly a very typical rule of thumb to not have the client testify. But I'll tell you, Chris, throughout my career, I've had quite a bit of success and luck with having the clients testify, right? I think it brings a nice element to the case in terms of humanizing them in front of the jury, right? They get to learn a little bit about the client. It's not just this person sitting next to me accused of a crime. They get to find out, where did this person grow up? What's this person like? How do they communicate? Do they have a family? What do they do for a living? Right? And it becomes more than just a person who's sitting there accused of a crime. It's a real person. Then have to really make sure they get it right.
So I got to disagree with something you said. You said a lot of your success, one of the things you pointed to was luck. I wrote luck down because there's no such thing as luck. I think your success is based on preparation in getting to know the facts and your client, as well as presentation. That leads to success. Luck is the result of preparation and presentation. That's just my way of disagreeing, because when people say you were lucky, I always say it takes away from the time and attention and preparation of the lawyer. So your clients are the beneficiaries of your success because of your preparation, not luck.
Well, I appreciate that. I don't know if I agree with you, in all situations, but yeah, I appreciate that.
There may be smidgens of luck, but luck doesn't happen if you're unprepared. If you're unprepared, you will not get that much luck and success.
Fair enough.
So let's hear about your client's testimony.
So he testified. He did a good job. He basically explained to the jury, what he did that day, what happened, talked about the affair that he had with this employee in the past, and, owned up to it and admitted that it was a tremendous mistake, but that he had ultimately, stayed with his wife and that she was kind of working through, forgiving him, and, they were working on their relationship essentially. But yeah, we got through to the end of it, and yeah.
You call your client, and the prosecution probably doesn't know he's going to testify or expect him to testify, I'd imagine.
Right. I'd say probably not. And so they cross-examined him. The prosecutor really wanted to get into this affair, of course, right? Because that's kind of the crux of the case at this point. It seems like, what is this affair? And so he's really prodding him and trying to figure out, well, what's your definition of an affair? And it kind of came out that it was an emotional affair, right? And that it sounded like it had never gotten physical, but, my client tried to clear up and clarify that, it was a two-way thing. It wasn't just him, like the husband had said.
So essentially, your client and the accuser, there was no sex was involved, but they crossed the line as far as their communications with each other.
And so, after that, this is kind of what I was referring to earlier, is that question, do I call the wife or not? Was that enough? Or do we need to kind of hammer the point home? That was our theory, right? That provided the motive for the accuser and the accuser's husband, right? The accuser's husband was frustrated about this prior affair. That's why he would make up this allegation. And the accuser was frustrated because my client ultimately decided to go back to his wife, right? And not, go any further in this relationship with her. So
I'll say this, Mike. I wasn't as fortunate as you in the sense that you talked about you thought you might do family law until you saw like, oh no, I don't want to do this. So I did family law for 3 years. I've been a lawyer for 18 years now. Well, it'll be 18 years in about a week and a half. So let's say I've been a lawyer for 18 years, and for 3 years, The first 3 years of my practice, I also did family law. And I will say that there's quite a few cases where the spouse is more upset with the emotional attachment their spouse develops to somebody else. And typically, they're more forgiving if it's just physical encounters, or whether it's one or multiple. Physical encounters are, for a lot of people, are easier to overcome and forgive than an emotional attachment. Like, you're talking to this person about things that are sacred, or I thought were sacred to, just the two of us. In your case, it didn't arise to a physical encounter. I think that could be actually more difficult to deal with. And before I just assume, let's hear how your client's wife perceived this and how she testified in court.
And I think you're exactly right. I mean, the prosecutor made an attempt to kind of minimize this because there was no physical relationship. But you're right, an emotional relationship that can hurt deep. That can hurt deep if it's with the wrong person when you're married. I had to make that decision. Do I want to call her, not knowing 100% what she was going to say, but I was confident enough in my client that there was this affair. I had confirmed with her previously that there was an affair, so I felt safe enough, and I thought it was important enough that it was worth the risk. So we called her to testify, and she did a great job. She confirmed, that there was an affair. She said it was two-way, both ways. And I said, and how did this come to light, right? And something that we had previously discussed, that she told me previously, that it was actually the accuser's husband who told her about it. And so I said, did he tell you that, it was just your husband coming after his wife? And she was very clear. No, he made it clear that it was, both individuals. Yeah. So I think that was really what solidified it with the jury.
Because she was able to essentially challenge the credibility of the accuser and her husband.
And you could tell she was hurt. I mean, you could genuinely see in her testimony that she was hurt by what happened and that she was struggling to forgive her husband, but that she was working on it. So I thought she did a good job of being very authentic for the jury.
So after your client and his wife testify, does the prosecution call any rebuttal witnesses to challenge what they had testified to?
No, that was it. So those were all the individuals who testified. You kind of talk about, we've had this theme of family law throughout our discussion. I mean, it almost felt like a family court drama, right? At that point. And, as we do in Kentucky, we move for directed verdict after the close of the prosecution's witness. And then in order to preserve that, and when I say directed verdict, of course, asking the judge to find my client not guilty, saying that the prosecution hasn't been able to prove their case. Of course, you know that. But then at the close of our case, we've got to renew that motion in Kentucky to preserve that, that motion that we make for a directed verdict. And so when I renewed it, I told the judge, I said, Judge, all we have from the prosecution is testimony from two biased witnesses, the husband and wife. And he kind of looked at me and paused and said, Counselor, I think we've got testimony from four biased witnesses. And I kind of laughed. And I said, I probably shouldn't be laughing, Judge, but okay, I hear what you're saying. So
he denies it, I'm assuming.
He denied it. He denied it. Yeah, so he wanted to put it in the hands of the jury.
So this happens before closing argument, right?
That's right.
All right, so now the judge has denied your motion for a directed verdict, and the prosecution goes first in closing, or does the defense go first?
Defense goes first, and prosecution gets the last bite at the apple.
Okay, so I would prefer that over what we have here in Louisiana.
Yeah.
So in Louisiana, the prosecution closes, and then the defense closes. So we essentially get sandwiched in the middle because they get a rebuttal closing. So sure. I have to respond to their closing and my closing and anticipate what they may say in rebuttal. Once again, that's one of the things we hear in this great state of Louisiana, where we still have a lot of Jim Crow laws on the books. And we just got unanimous verdicts a few years ago. First 15 years of my practice, which would have been the entirety of everybody else's practice, you can convict somebody in Louisiana with 10-2 verdicts. And
Wow.
we routinely saw those. And it was essentially a Jim Crow law to minimize the impact of minorities on juries. You get one or two minorities or people who would essentially hold the state to their burden, and you could just discount those. All they needed was 10,
Wow.
and there was a lot of convictions until the U.S. Supreme Court held it unconstitutional. So, with that being said, let's hear the highlights of your closing argument.
What I like to do in cases like these is just lay out, how important of a day this is for my client. I tell the jury that this is the most important day of my client's life. This is the day that will determine, whether they get to go home to their family tonight or not, whether they have a criminal history on their record or not. Right. And I let the jury know that this has been an intimidating process for my client. The Commonwealth of Kentucky, they have a tremendous amount of resources, so many police officers and investigators, prosecutors, like the prosecutor we had that day with a lot of experience, right? And that it's a process that has been challenging for our client. And then kind of going through the fact that the prosecution, they get some of these advantages, right? The advantage to go first and the advantage to go last, like I touched on earlier, that this is the last time that they're going to hear from me. And the prosecution gets to have the last say because they do have such a high burden in this case. They have the burden to prove my client guilty beyond a reasonable doubt, right? But then I like to go in and say, but there's a golden thread through all of this, and that's the presumption of innocence, right? And that it's not like that in every country, right? But America, we have the presumption of innocence, right? So we've got to be able to hold the government, in their feet to the fire, right? They have to be able to prove their burden and also to explain how high that burden is, right? That it's the highest burden in the legal system, right? Higher than the burden it requires for a jury to issue a $10 million verdict, higher than the burden that's required to take a child away from their mother in family court, right? It's the highest burden because we're talking about our client's freedom, And so I really want the jury to understand what the stakes are and what it's been like for my client going through this process. And then I like to go through the evidence, what we've heard, and really argue the case, right? Highlight all the positives and then things that maybe hurt us, counteract those with an argument, explain, why our theory of the defense correct, right? And then ask the jury to deliver the only verdict that the evidence reflected, which is not guilty.
So, what I want to say is that I'm sitting here and I'm listening to how you really take your time and massage. That's a term I got from David Ball. It's called massaging the law or the jury instructions. But you take your time with the presumption of innocence. And even though I do it and talk about it almost daily, I love the way you take your time and kind of make sure the jury appreciates and holds on to it and uses it, because the presumption of innocence is not just for the defendant, it's also for the jury. In trials I do, I call it the pillow test. Whatever verdict you render in this case, that presumption helps protect you and the defendant in that you get to go home, lay your head on the pillow, and sleep comfortably knowing you made the right decision because you adhered to what the law required and you appreciated and recognized and respected that presumption. And when that happens, juries typically get the right verdict. I say the right verdict for the right reason. So that's great how you use that. And I swear you inspired me to spend a little more time on that presumption in my own jury trials. So yeah, thank you for that.
And to be honest with you, I mean, it's something that I saw done by previous attorneys, right? Because I was thrust into a leadership role with the public defender's office where I ran an office in Eastern Kentucky for 2 years. And at that time, I hadn't tried a lot of cases, one or two. And so I was terrified. I went into court and I watched, some of the best defense attorneys in the area, deliver closing arguments and really just kind of learn from that, take from that, borrow from that, and see kind of how they did that very thing. So it's definitely not original, but when I see something that's really good, I want to try to adopt it.
That's what I tell people. Most of the things that we do have, there's been jury trials in this country for hundreds of years, so we are borrowing a lot of concepts that others created. But that still requires work, right? You still have to take it, incorporate it, and make it your own. It's one of the things I got from the Jerry Spence Trial Lawyer College is be who you are. So as for me, like a comparison would be myself and my law partner. My law partner he's more aggressive than I am. Like my demeanor is calm, relaxed, I'm smiling, but I'm forceful when I have to be. And I never try to make myself be like somebody else or be like people assume criminal defense lawyers have to be overbearing, over the top, mean, aggressive no matter what. And that's not true. You can use a soft cross of a witness and still get your point across. You don't necessarily have to be mean and overbearing. And there sometimes you do, but it's really about being who you are, taking these nuggets that we get and incorporating them into what we do. And look, you go out and watch trials and listen to books, and there's a lot of people who do what we do, but they stop learning after law school. And if you stop learning after law school, you will stop improving after law school. So how does the prosecution respond to your closing argument?
He's a good prosecutor. He's been doing it a long time. I thought he gave a great closing argument. Really, I could see him trying to relate to the jurors, kind of get close to them, kind of direct them down the narrative, what the accuser said happened. I'm really trying to highlight the bits on the affair that he got out of my client, trying to minimize that as we've discussed, based on the fact that it wasn't physical. But yeah, I think he did a good job. Yeah, nothing in particular stands out to me, but yeah, he did a good job of trying to connect with the jurors.
So now that the closing arguments are done, I tell my clients after closing arguments, this is the most difficult part of trial for most lawyers, and that is waiting on a verdict, because at that point it's completely out of your hands. So I want to hear about your client. What do you notice in his demeanor as you guys are waiting on the verdict? How are you feeling as you're waiting on the verdict? And how long does it take for the jury to render their verdict?
It was such a messy courtroom drama that played out. I really didn't know what the jury was going to do. And I try not to, get too confident in my mind, right? I try to just honestly keep an open mind. My client, he seemed pretty calm, cool, and collected. We went outside, kind of took a breather. His family was out there. We kind of ran through scenarios. He wanted to know, if this happens, what are they going to do to me? If this happens, what's going to happen to me? So we kind of ran through some scenarios, and I wrote down the time that the jury went out. And then it was pretty quick. It was about 18 minutes until they came out and they said, yeah, the jury's ready. And I never know if short is good or bad. I never know. But one thing I do recognize and I picked up on, and I don't know if I heard someone say this or I just saw it myself, but when the jury comes back into the courtroom, if they look at my client, it's a good thing. And if they keep their head down, it's not a good thing, And so I caught a few jurors looking at him. So I thought, okay, we'll see if this theory holds true. And it did. So,
I agree with that. I think if they don't look at our table or look our way, we're probably in trouble. So what would you say this case taught you?
So I don't know if it necessarily taught me this, but it certainly reaffirmed God is good. I think my guy, he had made some mistakes in the past, but I think he was earnestly trying to get this right and get back on the right path with his wife and with his family. So, I think there was just some grace there, and I thank God too for the verdict, because these are so stressful situations, as right? I mean, there's just so much on the line for this guy. And I, of course, don't want to be a part of anything that is destroying his life, right? So yeah, I was just thanking God, in the moment and just reflecting on it.
I'll say that the case you tried, I would classify it as extremely difficult. And this is what I say and why I say that. When we have cases where we know our clients are clearly guilty and jail or prison is what should happen, those cases are easy to try. But it's when you have somebody who you genuinely feel is an innocent person, and this is going to completely change the trajectory of their life. Those cases are difficult. Like, you lose sleep over somebody like the client you had in this case. Let's assume for a second we don't even have the immigration issue that he was dealing with, which is a big deal because this family would essentially be broken up, maybe even permanently. But even if it was only a case where the client was looking at up to a year in prison, that's significant. Like, I don't know about you, but if I can't work for a year, my family's gonna be in trouble. There's gonna be some hard times. We're gonna have to start selling some stuff. But for those people who don't have things they can sell or savings that they could dip into for a year, their life has to start over. For a guy like you had in this case, he certainly didn't deserve any jail time, and it's great that the jury was able to render a verdict, but most importantly, it's great that he was able to find somebody like you who willing to go the distance. There's far too many cases where lawyers are like, oh, just plead to this misdemeanor and be done, or it's not even put the time and effort preparing for a case because in their mind the stakes are not high. Relatively speaking, maybe the stakes aren't high compared to the time some other clients are facing, but for this guy in this situation, the stakes were as high as they could get, and I commend you for going all the way on that one.
I appreciate that. And, I certainly leave that decision up to the client. But as you stated, it is important to find someone like yourself, someone who's willing to go the distance and try the case. Yeah, that is incredibly important.
What do you think the public should take away from this case and this situation?
It's scary what an accusation can do, especially in a case like this where you talk to the officer on cross-examination and you realize how little it is that he actually did to investigate the case, so you would hope that there would be maybe a little bit more that would go into it before deciding whether or not to bring the charges. And I think there are, certainly those investigators, I know there are out there who want to do their due diligence, and prosecutors who won't bring charges on flimsy accusations. But it is scary to see, what an accusation can do, how much it can upend someone's life.
I was talking to somebody yesterday about how easy it is for people to get charged. I just want the public to be aware that your client was essentially charged with this crime based on statements from a lady and her husband. And that is enough. That is enough for the prosecution to indict somebody and take them to trial and send them to prison. Though the testimony of a single witness is enough. And people don't realize that. They say, oh, well, they ain't got no evidence against me. All they got is that person's statement. That's hearsay. Well, it's not hearsay, number one. And number two, it is enough if a jury believes it.
And in this situation, you had the husband and wife, but without much consideration of, them both possibly having reasons to make an accusation, right? Without an understanding of the background or the history, because those questions weren't asked. And then, a bruise on an arm, a photograph of that, but without confronting the accused with that and getting their side of the story. So yeah, it definitely is scary.
Honestly, I don't even know if the bruise was on the arm on the day of the incident. Did the officer even check for the bruise? When did they send the pictures of the bruise to the police or the prosecution?
Yeah, right. That's a good question. It looked like it was something that was taken maybe that same day that they reported it, which I think they tried to the day that it allegedly occurred, but then weren't able to actually report it until the next day, the following day. But then we didn't get it until, like I said, several days after the discovery deadline, which was months down the road. So, we tried to, file pretrial motions on that, and those were, denied.
So we truly don't know when that bruise occurred. There will be more cases, more people in Lexington and other parts of Kentucky who are in need of services from a lawyer and a firm like yours. So where can they find you and connect with you?
So you can find us on surreylaw.com SUHRELAW.com. We're out of the Lexington office, but like I said, we've got locations in Cincinnati, Indianapolis, Louisville, and here in Lexington. So yeah, absolutely. Look us up.
Well, Mike, that's all I have. I certainly appreciate you doing this. This was great. I'd love to bring you back in the future for another not guilty verdict to talk about.
Sure, I'd love that. And yeah, Chris, thank you so much for extending this opportunity to me. I really enjoyed our conversation.
Same here, man. You take care.
All right, you too.
All righty. Bye.
Bye.